All right, today we are talking about video and audio surveillance. Very similar things, but very different at the same time. We've had a couple agents ask about this in different scenarios. Most time, where you're going to run into this is with sellers or a seller's home. With technology being what it is, I guess anytime you're anywhere and you've got your device with you, somebody's probably listening, whether it be Google, Amazon, something or other. So just keep that in mind that just about anywhere we go in today's world, there is some type of audio or visual equipment around you with an earshot that can basically pick up anything that you are saying. What we're talking about today is specifically audio and visual surveillance or recordings within a home. So if you're showing a home, you need to make your buyers aware that they very well could be and likely are being either captured on video or audio recording. So Ohio law looks at this a couple different ways. Right here at the top here, I've included a link to a video that NAR put together. I won't play it all right now here, but we'll just kind of head and show you with it. I don't remember the gentleman's name, but it's only about a 4-minute video NAR put together talking about, I don't know if you can hear that or not, Tom, on that end.
There's nothing doing anything right now.
Okay. So I can't think of the guy's name. Yeah, National Association of REALTORS. Go ahead and click that link. That'll walk you through their interpretation of that. And I think that guy is an attorney. I am certainly no attorney, so don't partake any of this as legal advice. It's just my understanding of what the law is. So legally speaking, and I believe Peg Rittenauer put this together, that's Ohio attorney here we have access to. During a listing appointment, the seller disclosed to my agent there is video and audio surveillance equipment on this property. The seller stated the intent to record the showings because he wants to hear what the buyers and agents are saying about his property. Is it legal for the seller to do this? Does the listing agent need to disclose to the buyer's agent that the showings are being recorded? And again, this goes to Ohio law. And like a lot of stuff that we do in our industry, it's not so much, there's the law and there's the code of conduct and the rules we've agreed to abide by with being a real estate agent and our agency and ethical duty to our clients. So, and they don't always coincide. So you got to kind of weigh one with the other. Again, Ohio law is obviously that's stuff that's going to get you thrown in jail and or fined. It's the same thing with the Ohio Board of Realtors and National Association of Realtors. So Ohio law addresses both. Ohio law, a seller is permitted to use surveillance equipment to video record his own property. Basically, they have called it the nanny cam rule. A seller should not, and this is anywhere actually, the seller should not record in locations where there's an expectation of privacy, for example, a bathroom. And that's my understanding of Ohio law in general. Anywhere you're out in public, there's what they call expectation of privacy. And this then travels also to a homeowner's home. So in their home, that's their property. This is, again, talking about video, like not audio recording, but video recording, can record any of that except where there's an expectation of privacy. So bathroom, any private area like that. Audio recording is very similar, but very different. Under Ohio law, it is in order to legally make an audio recording, at least one person, so one participant in the conversation, being recorded has consented to the recording. So one of the participants, the actual people talking in the conversation, has agreed to it and is acknowledging it and is aware that they are being recorded. Therefore, for a seller, not at the home, they're not there, they're just recording it, not being present and not part of the conversation. Therefore, a seller to use surveillance equipment or audio record a conversation during a showing of the property, one of the individuals of the showing would have to have consent to the recording, meaning that the buyer would have to acknowledge and accept that, and or the agent showing the property would have to do that, or anyone else party to that. So say, just to, I guess, go down that rabbit hole, if the home inspector was there and he was aware that there was an audio recording, but nobody else knew, and he's part of the conversation, I think technically would be allowed. That's just the letter of the law. The practicality, you would want to make sure that everybody there would know that they are being recorded. And if they're not comfortable with that, either those devices need to be turned off or they just couldn't go into the property. It's as simple as that. The homeowner owns a home. They can control their environment, what they want to happen in there. Doesn't mean everybody's got to like it, but that's the law with that. So if that does happen without consent, that is a 4th degree felony under Ohio law.
I got a question for you.
Yes,
on that
sir.
stuff.
Yep.
In case you're probably going to get to it, but my question is, how do we need to inform them and get consent? Is informing considered consent?
That's what we're getting right to that. Great question. We're going to get right into that then. So two ways to approach this while listing property. So the first approach is to request that the seller turn off the surveillance equipment during the showings or anytime the property is being accessed. So again, inspections, appraisals, anything like that. Anytime you're going, so I'm the buyer's agent, I'm bringing my people in. We'll get to how they're made aware, but I'm aware that there's equipment there. You can ask the seller to disengage it equipment. How you prove that it's on or off, I don't know, but that's, I guess, would be if you go into the situation saying, I did not agree to be recording. I'm trusting the seller turns that off. If for some reason it came to light that stuff, that there was a recording, you would have grounds to say, look, I did not consent to this. This is not admissible in any court or any panel or anything like that. Okay. The audio recordings, again, this applies to equipment, including in the terms of the listing agreement. So we, as the listing agent, now need to at least ask the seller, is there any audio or visual recording equipment and listening devices in the home? And again, with Alexa, Google Home, everything else, phones, there probably are. I don't know that we need to go that deep into that. I guess my question would be to the seller, are you recording or listening to any conversations in the home when you're not there? So audio, video. So, and again, video's fine. They're allowed to do that. They should probably disclose it. They're not legally obligated, but audio recording, it should be disclosed and needs to be notified to the person then. So okay. How we're doing this, how are we going to disclose this? So now we're wearing our listing agent hat. I think as an office policy, once we find out now that there is listening equipment, there is audio equipment, we will put that into the agent remarks in the MLS and also put that in the showing time. So if, just to pick on somebody, Brittany requests a showing on 123 at Main Street, that's our listing. She should see it in the agent remarks on the MLS that there is audio and visual recording equipment present. And that's really all you got to say is that. I don't think you need to go into any more detail about what it is or where it's located or whatever. If they have a problem with that or they have an issue with it, they need to bring that to us. I don't know that we need to put the onus on ourselves or clients or whatever to, hey, are you okay with being recorded? Are you, if they ask, I would maybe get it in an email, print that, keep it in your file, keep it in a digital file, however you want to do it. But we'll put it in the agent remarks and then showing time under the showing notes. So you have access to 123 Main Street tomorrow at 12 p.m. Lockbox code is this. Audio and video recording equipment on premise or actively being engaged, or how some way you want to word it, just so that the words are being recorded is in that. Maybe we can come up with more specific language to that. Yeah, if you have any questions.
If you had something that you as an office wanted to have as a carte blanche, I think we would probably ought to add that to if it's not going to be on the listing agreement, we ought to have a separate, maybe that's part of the social media.
Yeah, well, that's the fire lens form. That is one of the topics I think coming up is talking about audio and visual and putting that in there. So I think we'll wait to see what that looks like. But I guess just for the moment, we'll go ahead and put that in there. So again, consent to audio recording should be obtained in writing. Again, I think that would be one of if the person has an issue with it. If we've done our due diligence and notified that agent, which that agent shouldn't, they've been made aware. They know that that's happening.
That's one of the parties at the showing has been notified.
Correct. Yep. They're made aware that it's there. If they do not consent at that point, they need to say, I'm not okay with this. I'm not going to consent to this being happening. Then that's where that conversation need to happen. Like, look, I'll talk to the seller. If they're still adamant they want to record it, then you would need to go back to that buyer's agent and say, I'm sorry, I appreciate what you're saying. However, the seller's home, they're not comfortable not having something recorded or whatever the case may be. The audio equipment is going to be on in recording, and at that point, I would put in an email something that can be kept. Yeah. So if property has surveillance equipment, the seller should be made aware, according to Ohio law, it should be disclosed. Again, at any point, this is just kind of just general practice. Buyer agent should caution your clients regarding property surveillance equipment and should never do or say anything in the property that they would not want the sellers to know. And I think all of us are probably pretty good about that. But just to reiterate that, it doesn't have to be every home you go into, but just make sure you have that conversation prior to getting into a home, making sure that the buyer knows that they are likely to be recorded if they are entering somebody else's home. So don't say anything about pricing, condition of the home, anything that they don't want the seller to know. They would not want to talk about it in the property, especially even if it's 10 houses later and they get into a home and they get really excited about it. That's when they start, oh my gosh, Johnny, I love it. I'll pay whatever for it. Get it for me. You kind of want to stymie those conversations as much as you can. Again, get NAR, put out some more. Again, person should have a reasonable expectation of privacy in areas, that aren't public, private bathrooms, things like that. If you have more questions about where, I did a little more digging then too. This is a little bit out of date, but I don't think it's changed from my experience then. So Ohio law is one party to a communication must consent. So again, just to clarify with that, if I'm in a conversation, I can record it, or I can know it's being recorded and it is admissible in court. It's admissible in any kind of panel or anything like that. If I'm not aware, if no party within the conversation is aware of it, that would be, you would need a warrant basically to have that done, or some kind of private investigator license to kind of do that stuff, to make it admissible or make it legal. So clarify, if you have a listing, just make sure you have the conversation with your seller. Do you have any audio or visual recording equipment in the home? If so, do you plan on using that while there's any other showings, or you are not present in the home? Is there going to be any type of recording with the property? If that is the case, we need to notify buyer's agents. And again, we do that in the agent remarks in the MLS, and then we'll put that in showing time so they are made aware. If they have an issue with it, you need to have that conversation and hash that out, what's going to happen with that. Make sure that's in an email or some format that can be kept. Keep that in your file. From the buyer side, make your buyers aware that the likelihood of them being recorded is high in just about any home they go to. So make sure they're aware of any conversation they have. The seller will probably know about it. So that is it. If you have any questions, let me know as the forms change. If we need to add a form to the office, we will. But I think the Firelands forms are going to adapt some of this language, and we'll go from there. Again, if you have any questions, let me know.